There's exactly one comparable case in American history, and I'm sure the court is aware of it. The parents of the Oxford High School shooter, convicted of involuntary manslaughter for 4 deaths, were sentenced to 10 to 15 years with their counsel run concurrently. And Your Honor, their warnings were sharper and closer than anything in this record. They bought the gun 4 days before the shooting. They were called into the school the very morning of the attack, asked to take their son home, and declined to do so. They were shown their son's drawing of a gun and the words, quote unquote, "the thoughts won't stop, help me." And they said nothing to the school about the weapon that they had recently purchased their son, and they left him in that school. 10 to 15 years concurrent was the considered judgment of that court after victim impact testimony that was every bit as devastating as what the court has heard in the past week and today. We would ask this court not to make Georgia the national outlier in this first case of its kind against a defendant whose warnings came with less and whose efforts were more. Briefly, Your Honor, as to merger, we have filed a brief. We are asking, as a case of first impression in Georgia, we believe that all of the counts should merge into count 1, based upon the fact that Colin failed to do one thing. Now, I understand, without waiving any objection, the court may disagree with that argument. And as I said, I would understand, because this is a sentence of first impression and an issue of first impression. Every count in this indictment arises when one continuous course of conduct, one gun, one child, one failure of perception over a span of months. The 18 cruelty counts do not describe 18 separate decisions by Colin Gray. They count the children present when the son acted. The number of those children is a proper measure of the gravity of this harm, and the court should weigh it in fully fixing the term. But to stack negligence counts consecutively is to count that gravity twice. We would ask the court, if it disagrees with our argument on merger, to run all the counts concurrent. Colin Gray did not choose his circumstances. It arrived by a telephone call from the Division of Family and Children's Services telling him to come get his 2 youngest children because their mother had relapsed. Throughout he and Marcy's marriage, it seemed her sole contribution to this family was to insert chaos. Immediately and without condition, when he received that call, he drove down and picked up his 2 youngest children and brought them back to monitor. Was he overwhelmed? Was he underprepared? Yes. Did he have a support system? No. Will the state argue that had he cooperated more with the school with defects, that he could have had a support system? I'm sure they will, and we do not contest that. That, too, is part of the failure that the jury found and for which he will have to answer. But an overwhelmed father's imperfect engagement with bureaucracies is negligence. It is not indifference. This is a father who was trying. This was a father who was constantly in touch with his children. Your Honor saw the text messages that were admitted to evidence at school. Colin Gray was positive. He told his son that he loved him, that he was proud of him. He encouraged him to go to school. He told him how happy he was when Colt told him that he had a good day at school. This was not an absent father. This was not a distant father. This was not a harsh parent. And the rifle, the court should understand what the rifle was meant to be, because it belongs to a larger and sadder inventory. Colin's plan for his son was the only plan that he had ever seen work. His relationship with his own father was a troubled one, and it was redeemed to the extent it could be in the woods, hunting, side by side with his dad. Your Honor has a letter from his sister that details that a little more clearly. So when Colin's own son began to slip away from him, Colin reached for everything he could think of and everything that he could afford. He bought his son gifts, guitars, computers, gear. He tried, however ineptly, to get him back into school. He filled out the constant counseling paperwork. He took him to the range. He took him hunting. And the hunting rifle, because hunting was the language in which a great father had once managed to say to a great son what he could not say in any other way. He believed that his presence and his generosity in the outdoors could pull Colt out of troubled waters. What he did not comprehend was the current that ran through a world. And one more thing about Colin. From the first hours of September 4th, as the court saw, he cooperated. He sat with investigators that same day. No lawyers, no conditions, and he told the truth. In fact, the state built his case on his own candor. He has no prior felony record. He's been in custody 22 months now. There is no world in which Colin Gray will reoffend. Specific deterrence and incapacitation are simply not a part of this case. And his punishment did not begin with the verdict, and it will not end with his release. His son is in prison for life. His daughter is in foster care. His youngest son is in foster care. His family is gone. His name will forever be associated with this tragedy for the rest of his life and afterwards. The state may tell the court this case demands a message. Your Honor, that message has been sent. On March 3rd, a unanimous jury delivered the first conviction of its kind in the history of Georgia, and it was reported throughout the state and throughout this country. Every gun-owning parent in Georgia already knows that the law changed that day. Deterrence requires credible condemnation. It does not require that a 55-year-old first offender die in prison for negligence. A decade or more behind bars, following the first conviction of its kind, is a thunderous message by any account. So here's what we are asking of the court. On each count of murder in the second degree, we're asking the court to sentence Mr. Gray to 20 years, to serve 10 years in confinement, with the balance to be probated. On the counts that survive merger, 10 years concurrent. On the reckless conduct counts, 12 months concurrent. All the counts concurrent with each other. An effective sentence of 20 years to serve 10 years in custody. That is not leniency. 10 years in a Georgia prison for a man who never intended to harm a single human being is among the most severe sentences ever imposed on a parent in American history for the act of a child. It honors the statutory minimum. It accounts for every life lost and every child endangered. It stands beside the crumbling sentences rather than dwarfing them. And it preserves the one distinction this week of sentencing will be remembered for: the difference between the boy who carried that rifle and pulled the trigger and the father who did not see it coming. Your Honor, we understand the gravity of this situation. 4 people are gone, and nothing the court can do today can change that. But the question today is narrower, and in some ways harder. What does justice require when a father's negligence and a son's concealed intent meet on a single morning? This court has heard from the son himself and how completely that intent was hidden from the father. It has found that this was done for the infamy of it, the currency of a world the father never knew existed. It is already imposed on the one who did the killing the heaviest sentence the law allows. The sentence can be severe and still be just. We ask the court to impose one that is both, the sentence we've asked for, and to leave standing the line has always drawn between negligence and murder. Thank you.